Getting an O-1A visa approved is not about being talented. It is about proving that talent in the exact language USCIS requires. Most applicants who qualify on merit fail to qualify on paper, and the difference is evidence. The O-1A is a non-immigrant visa for individuals of extraordinary ability in business, technology, the sciences, arts, or athletics. USCIS requires you to satisfy at least 3 of 8 specific criteria: prizes and awards, professional memberships, press coverage, judging roles, original contributions, published work, high salary, and leadership in distinguished organizations. Meeting 3 criteria sounds manageable until you realize that most immigration attorneys will only work with evidence you already have. If your file is thin, they format a thin file. That is the gap this video addresses. And it is why so many qualified professionals either abandon their O-1A case or pay far more than they should for results they could have reached sooner. Who does this affect most? H-1B holders whose visa clock is running out and who cannot rely on employer sponsorship. Founders who were never eligible for an H-1B in the first place. Researchers and engineers who have published work or built notable products but have never structured that story for USCIS. Designers and creatives with international recognition but no formal awards on paper. And self-filers, professionals who are not willing to pay an $8,000 to $15,000 attorney retainer when the underlying case has not been properly built yet. All of these people share the same problem. They know they have done exceptional work. They cannot yet prove it in a way that satisfies an immigration officer. Here is what that looks like in practice. A software engineer has 5 published papers and a well-known open-source library. Strong start. But her file is missing judging experience and press coverage. An attorney reviews her materials and says she needs more. That is accurate. But the attorney does not tell her which review panels would accept her nomination, which trade publications cover her field, or who the editor is. She is left to figure that out alone or to hire a separate PR agency at additional cost. Consider a founder who raised a seed round, got featured in a regional tech blog, and built a product used by thousands. He has contribution evidence, but nothing that clearly maps to 3 criteria. He needs an award, a speaking slot, and 1 more press mention in a recognized publication. But he does not know which awards accept nominations in his field, and he has no starting point for approaching conference organizers or podcast producers. These are solvable problems. They are just not being solved by the available options in the market. This is where Laurel comes in. Laurel is an evidence-building and case preparation platform for O-1A and EB-1A applicants. Laurel scores your profile against all 8 O-1A criteria, identifies the gaps, and then actively goes out and secures the missing evidence. That last part is what separates Laurel from everything else available. Law firms like Manifest Law, Beyond Border Global, Lighthouse, and Extraordinary are respected O-1A practices that do excellent work drafting and filing petitions. But sourcing new evidence is not what they are built for. They need a complete file before they can proceed. Laurel builds that file. Laurel indexes trade publications, awards programs, review panels, and podcast directories. It finds the named decision-maker behind each opportunity. Not the general submission inbox, but the specific editor, awards chair, or program director with a verified working email. It drafts outreach in your voice. You approve every message before it sends. When evidence comes in, Laurel maps it to the right O-1A criterion so nothing is wasted. You get live progress tracking across all 8 criteria. You can see exactly where you are strong, where you are close, and what is still open. When the case is ready, Laurel drafts exhibit descriptions and petition prose written to USCIS evidentiary standards. Gaps are identified in plain language. No invented numbers, no unsupported claims. That dossier then goes to your immigration attorney to sign and file, or you use it as a self-filer. The same case file also becomes the backbone of an EB-1A green card self-petition when you are ready for that next step. What does that mean for you in practical terms? You can retain manifest law, lighthouse, beyond border global, or extraordinary. Send them a Laurel prepared case file and significantly reduce the time and cost of assembling evidence from scratch. Or you can self-file using Laurel's Petition Pros and avoid the full retainer entirely. Laurel offers 3 plans. Rising Talent at $249 per month. Distinguished at $329 per month. Extraordinary at $449 per month. No retainer. No long-term contract. Cancel at any time and keep the complete case file. Laurel moves at the pace your visa timeline requires. If you are building an O-1A case in 2026, start at hirelaurel.com. Laurel gives you a scored gap analysis, finds the evidence you are missing, and prepares a dossier your attorney can take to USCIS with confidence. Laurel is not a law firm and does not provide legal advice or file petitions. Laurel builds and documents O-1A evidence and works alongside your chosen immigration attorney, or supports you as a self-filer. Information is current as of 2026 and is not a substitute for legal advice.